This is a discussion on co-ownership as provided under Articles 484 to 501 of the New Civil Code. Article 484. There is co-ownership whenever the ownership of an undivided thing or right belongs to different persons. In default of contracts or of special provisions, co-ownership shall be governed by the provisions of this title. Co-ownership is that state where an undivided thing or right belongs to two or more persons. Co-ownership is the right of common dominion which two or more persons have in a spiritual or ideal or aliquot part of a thing which is not physically divided. In co-ownership, there is only one ownership, but it is shared ownership. Each co-owner owns a fractional or an ideal part of the object, but they cannot point to a specific part of the object. Co-ownership is not encouraged since it is very unwieldy. It is easy to have disagreements between or among co-owners. The following are the sources of co-ownership. Number 1, by law. Number 2, by contract. Number 3, by chance. Number 4, by occupation. And number 5, by succession. An example of co-ownership by law are party walls, party ditches, and the co-ownership of earnings by a man and a woman whose marriage is void or who are living together without the benefit of marriage. An example of co-ownership by contract is where two cousins, for example, buy a parcel of land, share in the price, and agree not to divide the parcel of land for 10 years. There is co-ownership by chance in case of commiction, confusion, and hidden treasure. There is co-ownership by occupation or occupancy when a wild beast, for example, is caught by several persons. In the case of Bunsalan versus Buon Liat, the Supreme Court held that the fishermen are co-owners of the whale that they caught. There is co-ownership by succession or will, as in the case of intestate heirs before partition, the successional estate being a co-ownership prior to partition. The following are the characteristics of co-ownership. 1. There must be more than one owner. 2. There is one physical whole divided into ideal shares. 3. Each ideal share is definite in amount but is not physically segregated from the rest. 4. Regarding the physical whole, each co-owner must respect each other in the common use, enjoyment, or preservation of the physical whole. 5. Regarding the ideal share, each co-owner holds almost absolute control over the same. 6. It is not a juridical person. It has no juridical personality. And 7. A co-owner is in a sense a trustee for the other co-owners. Thus, he may not ordinarily acquire exclusive ownership of the property held in common through prescription. Article 485. The share of the co-owners in the benefits as well as in the charges shall be proportional to their respective interests. Any stipulation in a contract to the contrary shall be void. The portions belonging to the co-owners in the co-ownership shall be presumed equal unless the contrary is proved. A co-owner's share in the fruits and expenses is always dependent on the co-owner's interest. The share in the benefits and charges is proportional to the interest of each. Thus, if one co-owner owns two-thirds, he shares two-thirds of the taxes. Contrary stipulation is void. To do so would be to run against the nature of co-ownership. Each co-owner shares proportionately in the accretion or alluvium of the property. This is because an increase in area benefits all. If a co-owner has paid the taxes to prevent forfeiture of the common property for tax delinquency, he could compel contribution from his co-owners. But if he has not yet paid, he cannot compel them to pay the overdue taxes to himself because, after all, taxes are due not to him but to the government. Article 486. Each co-owner may use the thing owned in common, provided he does so in accordance with the purpose for which it is intended, and in such a way as not to injure the interest of the co-ownership or prevent the other co-owners from using it according to their rights. The purpose of the co-ownership may be changed by agreement, express or implied. This article grants its co-owner the right to use the property for the purpose intended, but the interest of the co-ownership must not be injured or prejudiced, and the other co-owners must not be prevented from using it. Co-owners must respect the rights of the other co-owners. In the case of Pardell versus Bartolome, two sisters owned a two-story building. The first floor was rented out and the second floor was being occupied by one sister. The other sister was in Spain. The Supreme Court said that the sister occupying the second floor need not pay rent. The fact that she used the whole second floor is irrelevant. She did not prejudice the rights of her sister in Spain precisely because she was in Spain. But with respect to the first floor, which was occupied by the husband of one of the sisters, the husband should pay his sister-in-law one half of the rent for such portion. Otherwise, his sister-in-law would be prejudiced. Meanwhile, as a co-owner, one can use all of the physical unit. For example, a co-owner uses the entire car, not just a portion of the car. A co-owner does not have to pay rent for the use of the thing owned in common. Article 487. Any one of the co-owners may bring an action in ejectment. First scenario. A, B, C, D, and E are co-owners of a lot which is being squatted. A files an ejectment suit and A wins. All the other co-owners benefit. Do the other co-owners share in the expense? Answer, yes. One can argue that it is a necessary expense. Second scenario. A, B, C, D, and E are co-owners of a lot which is being squatted. A files an ejectment suit and A loses. May the other co-owners sue for ejectment? Answer, no, it is barred by prior judgment. Third scenario, A, B, and C bought a book on credit. They are co-owners of a book. In an action by the creditor against the co-owners, the creditor must sue all. Article 487 contemplates a situation when it is the co-owner who files the suit, not when they are the defendants. Article 487 is a case where one co-owner can bind the others. The other instance is under Article 489. The reason for this article is the presumption that the case instituted by one was really in behalf of all. After all, in one sense, a co-owner owns and possesses the whole. Moreover, ejectment cases are urgent and summary in character. Under this article, the actions covered by the term ejectment include the following: 1. Forcible entry, 2. Unlawful detainer, 3. Action publiciana, 4. Action reivindicatoria, 5. Quieting of title, and 6. Replevin. Article 488. Each co-owner shall have a right to compel the other co-owners to contribute to the expenses of preservation of the thing or right owned in common and to the taxes. Any one of the latter may exempt himself from this obligation by renouncing so much of his undivided interest as may be equivalent to his share of the expenses and taxes. No such waiver shall be made if it is prejudicial to the co-ownership. Expenses for the preservation of the thing owned in common as well as taxes must be shouldered by every co-owner in proportion to their interest. A co-owner has two options: 1. Pay for the necessary expenses or taxes, and 2. Can forfeit so much of his share which is equivalent to his interest to the co-owner who paid for the necessary expenses or taxes. The co-owner who made the advance has a right of reimbursement. The advancing co-owner only has the right to require payment. He may not demand the share of the co-owner. A co-owner has the right to compel the others to share in the expenses of preservation, even if incurred without prior notification to them, since the expenses are necessary, but he must notify them if practicable. A co-owner may exempt himself from this duty to reimburse by renouncing or abandoning for the benefit of the others so much of his undivided share as may be equivalent to his share of the expenses and taxes. Reimbursement covers only necessary expenses, like those for the preservation of a house in a ruinous condition, and not for useful improvements, even if the value of the property is thereby increased, the purpose of the co-ownership not being for profit. Renunciation cannot be implied by mere refusal to pay the proportionate share. If there is refusal to pay but no renunciation, the creditors can still collect from the delinquent co-owner. Here is an example when renunciation or waiver cannot be made because it is prejudicial to the co-ownership. X and Y are co-owners of a house badly in need of repairs in order to prevent a collapse. Before expenses are incurred, X cannot renounce if Y does not have enough money to cover the expenses. Y can therefore go ahead, contract with the repairman, and X would still be liable despite his previous renunciation. This is because if Y does not go ahead, prejudice would be caused to the co-ownership. Article 489. Repairs for preservation may be made at the will of one of the co-owners, but he must, if practicable, first notify his co-owners of the necessity of such repairs. Expenses to improve or embellish the thing shall be decided upon by a majority as determined in Article 492. Repairs for preservation may be made at the will of one of the co-owners. As much as possible, notice should be given to the other co-owners. The lack of notice only gives rise to the presumption that the repairs were not necessary. However, this can be proven otherwise. Article 489 is a case where one co-owner can bind the others. The other instance is under Article 487. Useful or ornamental expenses need a majority. Majority is computed not by counting heads but by majority of the controlling interest in the co-ownership. Can a co-owner go ahead with necessary repairs even against the opposition of all the rest? The answer is yes, because the negligence of the others should not prejudice him. If he has money, he may advance the funds and recover later from the others. If he has no money in the meantime, he can contract with the repairman, and all the co-owners will be liable proportionately to the creditors. Here, they may renounce their shares in the co-ownership in favor of the creditors. Article 490. Whenever the different stories of a house belong to different owners, if the titles of ownership do not specify the terms under which they should contribute to the necessary expenses, and there exists no agreement on the subject, the following rules shall be observed. Number 1. The main and party walls, the roof, and other things used in common shall be preserved at the expense of all the owners in proportion to the value of the story belonging to each. Number 2. Each owner shall bear the cost of maintaining the floor of his story. The floor of the entrance, front door, common yard, and sanitary works common to all shall be maintained at the expense of all the owners pro rata. Number 3. The stairs from the entrance to the first story shall be maintained at the expense of all the owners pro rata, with the exception of the owner of the ground floor. The stairs from the first to the second story shall be preserved at the expense of all, except the owner of the ground floor and the owner of the first story, and so on successively. This article has been superseded by Condominium Law, or Republic Act 4726 as amended by Republic Act 7899, which was approved by Congress on June 18, 1966. You please read sections 2 to 16 of the Condominium Act. Article 491. None of the co-owners shall, without the consent of the others, make alterations in the thing owned in common, even though benefits for all would result therefrom. However, if the withholding of the consent by one or more of the co-owners is clearly prejudicial to the common interest, the courts may afford adequate relief. An alteration is a change which is more or less permanent, which changes the use of the thing, and which prejudices the condition of the thing or its enjoyment by the others. Alteration is an act of ownership, may be material or metaphysical, and gives rise to a real right over the property owned in common. The following are examples of alterations. Number 1, sale, donation, or mortgage of the whole property. Number 2, sale, donation, or mortgage of a part of the property but with definite boundaries. 3, a voluntary easement. 4, lease of real property. 5, the construction of a house on a lot owned in common. 6, any other act of strict dominion or ownership. And 7, impliedly contracts of long duration. Article 492. For the administration and better enjoyment of the thing owned in common, the resolutions of the majority of the co-owners shall be binding. There shall be no majority unless the resolution is approved by the co-owners who represent the controlling interest in the object of the co-ownership. Should there be no majority, or should the resolution of the majority be seriously prejudicial to those interested in the property owned in common, the court, at the instance of an interested party, shall order such measures as it may deem proper, including the appointment of an administrator. Whenever a part of the thing belongs exclusively to one of the co-owners and the remainder is owned in common, the preceding provision shall apply only to the part owned in common. This article pertains to administration and better enjoyment. Acts of administration or management are those that do not involve an alteration, those that may be renewed from time to time, those that have transitory effects, that is, they do not bind the co-ownership for a long time in the future, those that do not give rise to a real right over the thing owned in common, those which, even if called an alteration, do not affect the substance or nature of the thing, and those for the common benefit of all co-owners and not only one or some of them. Acts of administration need a majority. Majority is computed not by counting heads but by majority of the controlling interest in the co-ownership. Article 493. Each co-owner shall have the full ownership of his part and of the fruits and benefits pertaining thereto, and he may therefore alienate, assign, or mortgage it, and even substitute another person in its enjoyment, except when personal rights are involved. But the effect of the alienation or the mortgage with respect to the co-owners shall be limited to the portion which may be allotted to him in the division upon the termination of the co-ownership. This article deals not with the right to the whole property but only with the right to the ideal or metaphysical share of its co-owner. Each co-owner has full ownership of his part and of his share of the fruits and benefits, and therefore, he may alienate, assign, or mortgage his ideal share. If a co-owner sells the entire common property, the sale is valid only insofar as his share is concerned, unless the other co-owners consented to the sale. When a co-owner sells his share to a stranger, it is the stranger who should participate in the partition and not the original co-owner, since the vendor has ceased to have an interest in the co-ownership. Article 494. No co-owner shall be obliged to remain in the co-ownership. Each co-owner may demand at any time the partition of the thing owned in common, insofar as his share is concerned. Nevertheless, an agreement to keep the thing undivided for a certain period of time, not exceeding 10 years, shall be valid. This term may be extended by a new agreement. A donor or testator may prohibit partition for a period which shall not exceed 20 years. Neither shall there be any partition when it is prohibited by law. No prescription shall run in favor of a co-owner or co-heir against his co-owners or co-heirs so long as he expressly or impliedly recognizes the co-ownership. To remain in a co-ownership would be to subject a person to the desires of the rest. Conflicts in management being bound to arise, the law as much as possible discourages co-ownership. Hence, No co-owner is, as a rule, obliged to remain in the co-ownership. Moreover, the right to demand partition never prescribes, as long, of course, as the co-ownership still remains. Under the following situations, a co-owner may not successfully demand a partition. 1. If by agreement for a period not exceeding 10 years, partition is prohibited. 2. When partition is prohibited by a donor or testator for a period not exceeding 20 years, from whom the property came. 3. When partition is prohibited by law, as in the case of the conjugal partnership property, except in certain instances. 4. When a physical partition would render the property unserviceable, but in this case the property may be allotted to one of the co-owners who shall indemnify the others, or it will be sold and the proceeds distributed. And 5. When the legal nature of the common property does not allow partition, like in the case of party walls. Article 495. Notwithstanding the provisions of the preceding article, the co-owners cannot demand a physical division of the thing owned in common when to do so would render it unserviceable for the use for which it is intended, but the co-ownership may be terminated in accordance with Article 498. A good example of this article would be the partition of an automobile owned in common. If to physically partition is not practicable, the co-ownership may end under Article 498. That is, the object may be allotted to one co-owner who shall indemnify the others, or if that is not practicable, it shall be sold and its proceeds distributed among the co-owners. Article 496. Partition may be made by agreement between the parties or by judicial proceedings. Partition may be governed by the rules of court insofar as they are consistent with this code. Under this article, partition can be extrajudicial or judicial. A person having the right to compel the partition of real estate should set forth in his complaint the nature and extent of his title and an adequate description of the real estate. He must also join as defendants all the other persons interested in the property. If, after the trial, the court finds that the plaintiff has the right thereto, it shall order the partition of the real estate among all the parties in interest. Thereupon the parties may, if they are able to agree, make the partition among themselves by proper instruments of conveyance, and the court shall confirm the partition so agreed upon by all the parties, and such partition, together with the order of the court confirming the same, shall be recorded in the registry of deeds of the place in which the property is situated. A final order decreeing partition and accounting may be appealed by any party aggrieved thereby. If the parties are unable to agree upon the partition, the court shall appoint not more than 3 competent and disinterested persons as commissioners to make the partition, commanding them to set off to the plaintiff and to each party in interest such part and proportion of the property as the court shall direct. If to make a physical partition is prejudicial, the land will be given to one co-owner who should reimburse the rest unless one asks that a public sale be made. The request for a sale is allowed to forestall collusion between the assignee and the commissioners regarding the land's value. Article 497. The creditors or assignees of the co-owners may take part in the division of the thing owned in common and object to its being effected without their concurrence, but they cannot impugn any partition already executed unless there has been fraud or in case it was made notwithstanding a formal opposition presented to prevent it, without prejudice to the right of the debtor or assignor to maintain its validity. Example: A, B, and C are co-owners of a lot. They are indebted to X for the construction of certain improvements thereon. In the partition proceeding, X is allowed to participate. If X did not participate, he is not allowed to impugn a partition already executed unless 1. X was defrauded, and 2. X has previously presented a formal opposition to prevent it. However, if the co-owners believe that the partition had been made validly, without the creditor being prejudiced, they have the right to prove their contention. Article 498. Whenever the thing is essentially indivisible and the co-owners cannot agree that it be allotted to one of them who shall indemnify the others, it shall be sold and its proceeds distributed. An example of an object essentially indivisible is an automobile. The termination of the co-ownership here is made not physically but by law. Hence, this article refers to what is called a legal or juridical dissolution. Here is the procedure for the legal partition. First, give the whole to one co-owner who will now be required to indemnify the rest. But if this is not agreed upon, as when nobody wants to get it or more than one desire it, there must be a sale, a public sale, such as an auction or a private sale. Of course, strangers are allowed to purchase. Article 499. The partition of a thing owned in common shall not prejudice third persons who shall retain the rights of mortgage, servitude, or other real rights belonging to them before the division was made. Personal rights pertaining to third persons against the co-ownership shall also remain in force, notwithstanding the partition. Example: A, B, and C were co-owners of a parcel of land mortgaged to M. If A, B, and C should physically partition the property, the mortgage in M's favor still covers all the three lots, which together formerly constituted one single parcel. If A alone had contracted an unsecured obligation, he would of course be the only one responsible. Article 500. Upon partition, there shall be a mutual accounting for benefits received and reimbursements for expenses made. Likewise, each co-owner shall pay for the damages caused by reason of his negligence or fraud. The following are the effects of partition. 1. Mutual accounting for benefits received. 2. Mutual reimbursement for expenses. 3. Indemnity for damages in case of negligence or fraud. 4. Reciprocal warranty for defects of title and quality. 5. Each former co-owner is deemed to have had exclusive possession of the part allotted to him for the entire period during which the co-possession lasted. And 6. Partition confers upon each the exclusive title over his respective share. Article 501. Every co-owner shall, after partition, be liable for defects of title and quality of the portion assigned to each of the other co-owners. Example: A and B, co-owners, partitioned their land. Later, C, a stranger, was able to prove that he really owned the lot belonging to B. Should B alone bear the loss? Answer: no, both A and B must bear the loss, in that A must give half of his portion to B because there is a reciprocal or mutual warranty against eviction. Co-ownership is extinguished: 1. By judicial partition. 2. By extrajudicial partition. 3. By prescription. When one co-owner has acquired the whole property by adverse possession as against all the others, and repudiating unequivocally the co-ownership of the others. 4. When a stranger acquires by prescription the thing owned in common. 5. By merger in one co-owner. 6. By loss or destruction. And 7. By expropriation. Here, the indemnity will be distributed accordingly. This is the end of this presentation. Thank you.